My name is Sophie Delacroix Marsh, and 2 weeks after my wedding, before the thank you cards were even finished, a trust attorney I'd never met called my cell phone instead of my husband's because, in her words, the amendment specifically listed you as the party required to be notified of any dispute regarding beneficiary marital status. I didn't understand the sentence at first. I asked her to repeat it. She did, slower, the way you repeat something to a person you can tell is about to have a very bad afternoon. My husband, Nathaniel, had been formally reclassified on his family's trust documentation as unmarried, not divorced, not separated, simply and specifically unmarried, as though our wedding, 14 days earlier, in front of 120 guests and an actual marriage license filed with the state of Connecticut, had never happened at all. His mother had done it, and she had done it, according to the document timestamp, 4 days after she'd hugged me at our own reception and told the photographer, on camera, "I've never seen my son so happy." Welcome back to True Family Drama, the channel for real stories of betrayal, justice, and the family members who thought a piece of paper could quietly undo what an entire wedding day had made real. This one is going to test your patience with in-laws in ways I don't think you're expecting, so stay with me all the way through, because the ending involves a courtroom, a very specific legal definition of the word fraud, and a mother-in-law who learned the hard way that trust documents are, in fact, extremely good at remembering exactly what someone tried to make them forget. If you're new here, subscribe, because there's a lot more like this waiting for you. To understand how a mother could try to erase her own son's marriage on paper less than a month after standing in the front row for it, you have to understand the family and the money first. Because in families like the Marshes, I've learned, the money was never really about comfort. It was about control. And control, once you've held it for 3 generations, does not enjoy sharing a room with a daughter-in-law it didn't personally select. I want to describe the Marsh family home before I go further, because I think it tells you something important about the atmosphere I was actually walking into, long before any trust document ever entered the picture. The house sits on 4 acres outside Hartford, a Georgian colonial Nathaniel Sr. purchased in the early 90s, once the family's real estate holdings had grown substantial enough to justify it, and every room inside carries some version of the same message. A formal portrait of Nathaniel Sr. in the front hall, a glass case in the study displaying awards from the Hartford business community spanning 3 decades, a dining room table that seats 14 and has, as far as I could ever tell, never once been used for a meal that wasn't at least partially about business or legacy, even at Christmas. I remember the first time Nathaniel brought me there, 4 months into dating, and feeling a specific kind of vertigo standing in that front hall, understanding for the first time that I wasn't just meeting a family, I was meeting an institution that happened to also function as a family, one with its own internal mythology about who belonged inside it and who was, at best, a guest with extended visiting privileges. Nathaniel's family built their wealth over 2 generations in commercial real estate development around Hartford, starting with his grandfather's small construction firm in the 1960s and expanding, under his father's leadership, into a genuinely substantial regional portfolio of office parks and retail centers. Nathaniel Sr. died 6 years before I ever met the family, leaving behind a complex trust structure managed by his widow, Constance Marsh, and a Hartford-based trust attorney named Priscilla Hendon, no relation to Priscilla Nkemelu from an earlier story, just, apparently, a popular name among excellent estate attorneys in the Northeast. The trust held the bulk of the family's commercial real estate holdings, structured to eventually distribute to Nathaniel and his younger sister Whitney under a set of conditions that, I would only fully understand once everything came apart, had been written with far more specificity around marital status than either sibling had ever bothered to read closely, the way you don't read the fine print on documents you assume will never actually matter to you personally. I met Nathaniel 4 years ago at a mutual friend's dinner party in Boston, where I was working as a structural engineer for a firm specializing in adaptive reuse projects. Old mill buildings, converted warehouses, the kind of work that let me spend my days climbing around century old timber frames deciding what could safely bear weight and what couldn't. I want to describe that first dinner party a little more, because the contrast between how Nathaniel and I actually fell for each other and the family structure I'd eventually marry into feels important to hold on to. We ended up seated next to each other almost by accident, a last-minute place card swap by our mutual friend who thought, correctly as it turned out, that we'd get along. Nathaniel spent the first 20 minutes of the meal asking me detailed, genuinely curious questions about how you actually determine whether a 140-year-old timber beam can still bear modern load requirements. Questions specific enough that I remember thinking, halfway through my answer, that this was the first date-adjacent conversation I'd had in years where someone wanted the actual engineering explanation instead of a simplified, flattering version of my job. He told me, later that same night, that his own work as an architect had made him fall in love with old buildings for almost the opposite reason I had, where I was drawn to the hidden structural honesty underneath a building's surface. He was drawn to the way a good renovation could let a building's original character breathe again without erasing its history. We spent the rest of that dinner, and most of the 4 years that followed, building a relationship out of exactly that shared instinct. An interest in what's actually holding something up, and a refusal to simply trust the surface presentation of a structure without examining what's really underneath it. I think, looking back, that instinct is exactly what eventually let both of us recognize Constance's trust memo for what it actually was, rather than accepting its surface-level administrative language at face value, the way a less structurally minded couple might have. I want to mention my job specifically, because it matters later, in a way I couldn't have predicted the night we met over a shared appetizer neither of us had ordered. Nathaniel was funny in a dry, understated way, worked as an architect at a firm that occasionally overlapped with mine on projects, and had a habit of asking real questions instead of performing interest, which, after a string of forgettable dates that year, felt like discovering an entire register of conversation I hadn't realized I'd been missing. Constance, I should say clearly, was never warm to me. Not once. Not from the very first dinner I had at the Marsh family home 8 months into dating Nathaniel. She was polite in the specific, clipped way that functions as its own kind of message, asking about my little engineering projects, a phrase she used with a consistency that felt too precise to be accidental, complimenting my dress at a holiday party by saying it was brave for the room. And once, memorably, at a family gathering I wasn't technically supposed to overhear, telling her sister on the phone that she just wished Nathaniel had met someone from a family we actually know. I told myself, for years, that this was ordinary mother-in-law territory, the kind of low-grade skepticism that eventually softens once a woman proves herself reliable, patient, worthy of the family she's marrying into. I want to be honest that I believed that story about Constance for far longer than the evidence actually supported, because believing it was easier than confronting what I think I already sensed underneath her politeness. That Constance did not experience me as a person to eventually welcome. She experienced me as a variable she hadn't personally selected, sitting inside a financial structure she had spent 30 years building around her own children alone. Nathaniel proposed 2 years into our relationship, at the same mill building in Providence where we'd first bonded over a shared professional obsession with exposed timber trusses, which felt, to both of us, like exactly the right kind of romantic. Constance's reaction to the engagement, when we told her in person, was a tight smile, a hug that lasted exactly as long as a hug is supposed to last, without conveying any actual warmth, and a single sentence that I didn't fully understand the weight of until 18 months later. Well, I suppose we'll need to have Priscilla look at a few things. At the time, I assumed she meant updating beneficiary paperwork in the ordinary, unremarkable way families sometimes do around a wedding. adding a daughter-in-law to an emergency contact list, that sort of administrative housekeeping. I did not understand, until the trust attorney called my cell phone 2 weeks after my own wedding, exactly what having Priscilla look at a few things had actually meant. Our wedding itself was, by every account except what I'd eventually learn about the paperwork happening quietly around it, genuinely lovely. We married in June at a restored barn venue outside Litchfield, 120 guests, Nathaniel's sister Whitney as maid of honor, giving a toast that made half the room cry, Constance seated in the front row in a pale blue dress, dabbing her eyes during our vows in a way that looked, to every single person watching including me, like real emotion. I remember specifically the moment during the reception when the photographer asked Constance for a quote for our wedding album, and she said, smiling, looking directly at the camera, "I've never seen my son so happy. Sophie is exactly what this family needed." I have that photo. I have that quote printed in our wedding album, dated the same weekend, 4 days before the amendment I wouldn't learn about for 2 more weeks. I want to walk you through the actual mechanics of what Constance did, because I've since had to become something close to an expert in trust law out of sheer necessity, and I think understanding the specifics is what makes this story land the way it should, rather than just sounding like generic in-law hostility. Before I get into the trust mechanics themselves, though, I want to pause on something Rosalind told me early in our very first meeting, because it reframed how I understood the entire situation before we'd even discussed a single legal strategy. She told me that in her 15 years practicing trust litigation, the cases that involved actual malicious intent, a family member deliberately, knowingly falsifying a document to disadvantage someone, were far less common than the cases where someone exploited a genuine gray area in ambiguous language, technically defensible, even if morally indefensible. The scary ones, she told me, are the ones where the person doing the harm can point to some sliver of legitimate procedure and hide behind it. Your mother-in-law didn't just exploit a gray area, Sophie. She manufactured one, out of nothing, 4 days after personally witnessing the exact fact she claimed was unverified. That's not a gray area. That's a lie wearing a gray area's clothing. I've held on to that distinction since, because I think it's the thing that ultimately made the legal case as clean as it was. Constance hadn't found a clever loophole. She'd simply asserted something false and hoped nobody with the standing to challenge it would look closely enough, quickly enough, to catch her before the assertion calcified into accepted fact. The Marsh family trust, as I mentioned, distributed assets to Nathaniel and Whitney under conditions their father had originally written with input from Priscilla's firm. Standard language, the kind most trusts include, providing additional protections and considerations for a beneficiary's spouse, should one exist at the time of distribution, primarily around things like survivorship rights to certain trust-held properties and inclusion in a health and education support provision meant to cover a beneficiary's immediate family. Crucially, the original trust document defined spouse simply as a person to whom the beneficiary is legally married at the relevant time, verified, per the trust's own administrative procedures, by a marriage certificate filed with the trust administrator, which, in this case, was Constance herself, serving as co-trustee alongside Priscilla's firm, a structural detail her late husband had set up specifically so his widow would retain meaningful oversight during her lifetime, a decision I don't think Nathaniel Sr. ever imagined his widow would eventually weaponize against her own daughter-in-law. What Constance did, 4 days after our wedding, was submit what's called a trustee determination memo, an internal document, not requiring court approval for something this administratively minor, at least on its face, in which a co-trustee formally records a determination relevant to the trust's operation. In it, she wrote, and I have since read this document with my own eyes more times than I can count, that she had reviewed the available documentation and determined that Nathaniel's marital status for purposes of the trust remained unmarried, specifically citing what she described as insufficient certified documentation on file to verify the marriage meets the trust's requirements at this time. She had not asked Nathaniel for our marriage certificate. She had not asked me. She had instead simply asserted, in a formal trust document with her own signature as co-trustee, that verification was lacking, a technically defensible-sounding administrative claim that was, in actual fact, a lie, since a marriage certificate absolutely existed, had been filed with the state 4 days before her memo, and could have been provided to her within an hour of a single text message asking for it. Priscilla Hendon, the trust attorney, called me, not Nathaniel, because, as she explained when I finally understood the full context, the original trust document, in its section governing spousal verification disputes, specified that in the event a beneficiary's marital status determination was contested or under review, the spouse in question was to be directly notified as an interested party, a clause Nathaniel Sr. had apparently insisted on including, according to Priscilla, specifically because he'd seen enough family trust disputes in his career to want built-in protections against exactly the kind of quiet, administrative maneuvering his own widow would eventually attempt. I want to sit with that for a second because I think it's one of the most quietly devastating details in this entire story. Nathaniel's own father, years before his death, had anticipated that someone in his family might someday try to manipulate a beneficiary's marital status for financial advantage, and had built a safeguard into the trust specifically to make sure the spouse being erased would find out directly, rather than through her own husband's family deciding what she needed to know. Priscilla's phone call to me was measured, professional, clearly uncomfortable. She told me later she'd handled the Marsh family's affairs for over a decade and had never once anticipated needing to invoke this particular clause. She explained the memo, explained what unmarried status meant practically, that in the event of a trust distribution during that period, or in the event of Nathaniel's death, I would have no claim whatsoever to survivorship rights or spousal provisions. The trust otherwise would have guaranteed me. Provisions that, I'd learn, were not trivial, including continued access to a family-held property in Vermont, the Marshes used every summer, and a health support provision that, given my own family's history with expensive chronic illness, mattered to me far more than the real estate ever did. She told me I had the right, under the trust's own dispute procedures, to submit documentation directly to contest the determination, bypassing Constance entirely if necessary, precisely because the clause existed to protect against exactly this scenario. I called Nathaniel before I did anything else, sitting in my car in the parking lot of my own office, unable to make myself walk back inside and pretend to review structural drawings while holding this in my chest. He was, I want to be clear, as blindsided as I was, genuinely, visibly shaken in a way that told me immediately this hadn't been some quiet plan he'd known about and simply failed to mention. He called his mother the moment we hung up, and I could hear, even secondhand through his retelling afterward, that the conversation had not gone the way either of us expected. Constance's explanation, when Nathaniel confronted her directly, was almost breathtaking in its calm. She told him, according to what he relayed to me that evening, sitting at our own kitchen table still in his work clothes, that she'd simply been being appropriately cautious, given how quickly the relationship had moved. 4 years, somehow reframed by Constance in that conversation as reckless speed, and that she'd wanted to make sure the paperwork reflected a marriage that had actually been properly established before extending trust protections that, in her words, took your father decades to build and deserve real scrutiny before they're extended to anyone new. Anyone new. 4 years, a wedding in front of 120 guests, a filed marriage license, and I was still, in Constance's own vocabulary, someone new, requiring scrutiny before I could be trusted with what she'd apparently decided was hers to gatekeep, regardless of what her late husband's own trust document said about who actually held that authority. Nathaniel asked her directly whether she intended to correct the memo now that he'd confronted her. Her answer is the sentence that, more than anything else in this entire story, told me exactly who I was actually dealing with. She said, "I'll take another look once things settle down. There's no rush, Nathaniel. You're still married regardless of what a piece of paper says, aren't you? I don't understand why Sophie is making this into such a crisis." She had, in the very same conversation, both admitted the memo was factually wrong and refused to correct it, while simultaneously accusing me, the person she'd erased, of overreacting to my own erasure. I want you to notice that move, because I've come to recognize it as a pattern that runs through nearly every story on this channel in one form or another. The person doing the harm, reframing the person naming the harm as the one causing the actual disruption. I did not wait for things to settle down. Before I tell you about hiring Rosalind, I want to tell you about the 48 hours between Nathaniel's confrontation with his mother and the moment I called an attorney, because I think that gap is where I actually became the person capable of doing what came next, and I don't want to skip past it just because it doesn't involve a courtroom. I didn't sleep the first night. I lay in bed next to Nathaniel, who was doing the specific, restless not sleeping of a person replaying a conversation with his mother on a loop. And I found myself doing something I hadn't expected. Going back through 4 years of memory with a kind of forensic attention I'd never allowed myself before, because it had always felt petty, or paranoid, or simply unkind to catalog a woman's small dismissals as though they were evidence of something larger. That night, I let myself do it anyway. The comment about my job being little engineering projects, the brave for the room dress remark, a birthday dinner 2 years earlier where Constance had toasted Whitney's then boyfriend, now ex-husband Mark, with a full paragraph about how wonderful it is when someone joins this family who really understands what we've built. A toast she had never once offered in my direction, despite my having been present at every single holiday for 3 years running by that point. I want to describe one specific memory from that same night, because it's the one that surfaced last, and it stayed with me longest. About a year into dating Nathaniel, before I'd fully understood the shape of what I was navigating, I'd overheard Constance on the phone with a friend, describing me, in passing, as very independent, a phrase delivered with a particular flatness that I remember registering, even then, as something other than a compliment, though I couldn't have told you at the time exactly what it actually meant. Lying awake that night after Nathaniel's confrontation, I finally understood what very independent had actually meant in Constance's vocabulary, not a compliment about my self-sufficiency, but a coded complaint about a woman who couldn't be easily managed the way Constance was accustomed to managing the people around her. I want to be honest that cataloging all of this at 2 in the morning didn't feel like empowerment. It felt like grief, a specific, quiet grief for the version of myself who had spent 4 years hoping patience alone would eventually be enough, and who now understood, with total clarity, that no amount of patience was ever going to be the actual obstacle standing between Constance and her acceptance of me. The obstacle had never been my patience. It had been her refusal, and no version of me showing up more graciously, more competently, more warmly was ever going to change a refusal that had nothing to do with who I actually was, and everything to do with who I wasn't, namely, someone Constance had personally chosen. I called my own mother the next morning, mostly because I needed to say the situation out loud to someone who had no stake in protecting the Marsh family's reputation. And I remember my mother's response with total clarity, because it's the sentence that actually got me off my kitchen floor and into motion. She said, "Sophie, you've spent your whole adult life making sure buildings don't fall down on people. You know exactly how to read a structure and tell whether it's actually sound or just painted to look that way. Read this the same way you'd read one of your projects. Don't let anyone tell you the load-bearing wall is fine just because the wallpaper looks nice." I laughed, the first real laugh I'd managed in 2 days, and I think something about hearing my own professional instincts reflected back at me applied to a completely different kind of structure. is what finally let me stop treating my own judgment as something to second guess and start treating it as something to actually use. I retained an attorney of my own within 4 days, a trust litigation specialist named Rosalind Achterberg, recommended by a colleague whose own family had gone through a contested trust dispute years earlier, a woman with the specific kind of unbothered, methodical energy I needed at that exact moment. Because I was, if I'm honest, furious in a way that made me want to move faster and louder than was actually strategically wise, and Rosalind's entire professional demeanor functioned like a hand gently but firmly on my shoulder, slowing me down towards something more effective than rage alone could accomplish. Rosalind's first move was simple, and in retrospect, exactly the right opening play. She sent a formal letter, not a lawsuit, not yet, directly to Priscilla Hendon's firm as trust administrator, enclosing a certified copy of our marriage certificate along with the original wedding photograph Constance herself had posed for and the printed quote from our wedding album. "I've never seen my son so happy. Sophie is exactly what this family needed." Dated and time-stamped 4 days before Constance's own trustee memo claiming insufficient documentation existed to verify the marriage at all. Rosalind's letter made one specific surgical point: that Constance's memo did not merely fail to reflect available information, it affirmatively misrepresented information Constance herself had personally witnessed, celebrated, and publicly confirmed in writing, days before drafting a contradicting internal document, a pattern that, Rosalind noted, moved this well beyond ordinary administrative caution and into territory a court would likely recognize as bad faith conduct by a fiduciary, since co-trustees, unlike ordinary family members, have specific legal obligations to act honestly and in the beneficiary's actual interest, not their own preferences. I want to explain why that distinction, fiduciary versus ordinary family member, mattered so much to the entire trajectory of what happened next, because I think it's the legal mechanism that makes this story different from a simple in-law grudge that never goes anywhere. Constance wasn't just Nathaniel's mother expressing disapproval of his choice of wife, which, as unpleasant as that would have been, carries no legal consequence whatsoever. People are entitled to dislike their children's spouses, however much it hurts. Constance was a co-trustee, a formal fiduciary role with legal duties that exist independently of her personal feelings, and using that role to falsify a determination about a beneficiary's marital status in order to withhold benefits, the trust document otherwise clearly guaranteed, moved her conduct from unpleasant mother-in-law into fiduciary potentially in breach of her legal duties, a category with actual teeth, actual court oversight, and actual personal liability attached to it. Priscilla Hendon's firm, once Rosalind's letter arrived, moved with a speed that told me everything about how seriously an attorney with her own professional license on the line takes the words bad faith, fiduciary conduct, appearing in a formal letter. Priscilla contacted Constance directly, and I later learned, through the discovery process that followed, that the conversation between them had been considerably less gentle than any conversation Constance had had with her own son about the same subject. Priscilla, as trust administrator with her own duty to ensure the trust was administered lawfully, informed Constance that the memo needed to be formally corrected immediately, that the delay itself was creating liability exposure for both Constance personally and potentially for Priscilla's firm if it wasn't addressed promptly, and that continued refusal could result in Priscilla petitioning the probate court to remove Constance as co-trustee entirely, a threat with real weight, given that Connecticut probate courts do have the authority to remove a trustee for breach of fiduciary duty, and given that Priscilla, as an officer of the court herself, had professional obligations that would eventually require her to act regardless of her long personal relationship with the Marsh family. I want to describe the 2.5 weeks between Rosalind's initial letter and Constance's eventual correction, because I don't want to give you the impression that this resolved quickly or cleanly just because the legal mechanism itself was straightforward. Those weeks were honestly some of the strangest of my adult life. Going to work every day, climbing through half-demolished mill buildings, assessing load-bearing capacity with structural engineers who had no idea that outside of work hours, I was locked in a legal standoff over whether I was, in fact, married. Nathaniel and I barely discussed anything else during that period, and I remember a specific evening, about a week in, when he came home from a dinner with his mother, a dinner I declined to attend, needing distance more than I needed to keep up appearances, and told me that Constance had spent most of the meal talking about an upcoming charity gala as though nothing at all was happening between us, as though the trust dispute was a minor scheduling inconvenience rather than a formal legal challenge to her own fiduciary conduct. She asked if you'd be attending the gala, Nathaniel told me, sitting across from me at our kitchen table with an expression I hadn't seen on him before, something between exhaustion and a kind of dawning recognition. Sophie, I don't think she understands, even now, that what she did was actually wrong. I think she genuinely believes she was being careful. I asked him what he thought accounted for that, and he was quiet for a long moment before he said, I think, my whole life, nobody's ever actually made her sit with the consequences of managing people quietly. She's gotten away with it for so long it doesn't even register to her as something that could get away from her control. I didn't know it yet, but that sentence would turn out to be almost exactly what Priscilla told me herself, weeks later, using nearly identical language, about the specific reason Nathaniel Sr. had built the spousal notification clause into the trust in the first place. Constance corrected the memo within a week of Priscilla's call, formally reclassifying Nathaniel's marital status to reflect the marriage that had, of course, been real and verifiable the entire time. I want to tell you that this was the end of the story, the moment everything resolved cleanly, but it wasn't, because a corrected memo doesn't undo the 2.5 weeks during which I had genuinely, legally, on paper, not existed as Nathaniel's wife within a financial structure that, I'd learn, mattered more to our actual life together than either of us had previously understood. And because Constance's underlying attitude toward my place in the family had not shifted 1 inch simply because a court threat had forced her hand on the paperwork. This is where the story takes the turn that, I think, actually matters most, because Rosalind advised me that a corrected memo alone, absent any further accountability, would leave me in exactly the position I'd started in, legally married on paper, but with a co-trustee who had already demonstrated, in writing, a willingness to manipulate that paperwork whenever it suited her, with no real deterrent against her trying something similar again down the line, perhaps more carefully next time, once the immediate legal pressure had passed. Rosalind recommended, and I ultimately agreed, that we pursue a formal accounting and a petition to the probate court, not to remove Constance as co-trustee entirely, which felt, even to me in my angriest moments, like more disruption to Nathaniel's family than the situation actually required, but to establish a court-supervised protocol requiring any future determination regarding beneficiary marital or family status to be independently verified by Priscilla's firm directly, removing Constance's unilateral discretion over that specific category of decision permanently, regardless of how the broader family relationship eventually settled. The probate hearing happened 4 months after our wedding, a fact that still strikes me as strange every time I say it out loud. That 4 months into a marriage that should have been entirely about learning to share a life with someone, I instead spent a significant portion of it in a courthouse conference room with attorneys, discussing my mother-in-law's fiduciary conduct. I want to describe the hearing itself in more detail than I have so far, because I think the texture of it matters, and because it wasn't the dramatic, movie courtroom scene I'd half expected in the anxious weeks leading up to it. Connecticut probate proceedings of this kind happen in a much smaller, quieter room than I'd imagined. No jury, no gallery, just Judge Okonkwo Reyes behind a modest bench, a court reporter, and the attorneys arranged at two tables that felt, absurdly, like they belonged in a conference room, more than a courtroom. Constance sat beside her attorney in a charcoal suit I recognized from a funeral we'd attended together 2 years earlier, her expression composed in the same tight, controlled way I'd grown so familiar with over 4 years of holiday dinners. Nathaniel sat beside me, and I remember gripping his hand under the table hard enough that he later told me he'd lost feeling in 2 fingers, though he never once tried to pull away. Rosalind opened by walking the judge through the timeline with a clarity that made the entire sequence of events sound, laid out end to end, almost absurd in its transparency. The wedding on June 14th, the photographer's quote dated June 14th, the trustee memo dated June 18th, 4 days later, claiming insufficient documentation existed to verify a marriage that had, by that point, been publicly celebrated, photographed, and legally filed for 4 days. She introduced the wedding album page as an exhibit. Watch the judge read Constance's own quoted words. "I've never seen my son so happy. Sophie is exactly what this family needed," directly beside the exhibit showing the memo's contradicting language, and let the silence in the room do work that no amount of additional argument could have accomplished. I watched Judge Okonkwo-Reyes's expression shift almost imperceptibly as she read the two documents side by side, and I understood, in that moment, that this was the exact effect Rosalind had been building toward from the very first letter she'd sent weeks earlier. Not outrage, not theatrics, just the plain, undeniable juxtaposition of what Constance had said in public and what she'd written in private 4 days later. Constance's own attorney argued, predictably, that the corrected memo rendered the entire matter moot, that no actual harm had occurred since the trust had never actually made a distribution during the disputed period, and that petitioning for a permanent verification protocol was excessive, given that the underlying issue had already been resolved voluntarily. Rosalind's response to that argument is the part of this whole ordeal I find myself replaying most often, because I think it named something that had been sitting underneath my own anger without my having the words for it yet. She told the court, and I'm paraphrasing only slightly from my own memory of sitting in that room, that the absence of an actual financial distribution during the disputed period was, in this case, a matter of fortunate timing rather than protection, that had Nathaniel been in a car accident during those 2.5 weeks, God forbid, the trust's own language, absent Rosalind's intervention, would have left me with no survivorship claim whatsoever on the basis of a document his own mother had signed while knowing with absolute certainty that it was false. The harm wasn't hypothetical simply because the worst-case scenario hadn't occurred. The vulnerability had been real, deliberately created, and had existed for over 2 weeks before anyone with the power to correct it even knew it was happening. The judge, a measured, clearly experienced probate judge named Judge Okonkwo-Reyes, agreed, granting the petition for independent verification on all future family status determinations, and, notably, ordering Constance to personally cover both parties' attorney fees related to the petition, a detail Rosalind told me afterward was the court's way of formally signaling, on the record, whose conduct had actually necessitated the entire proceeding. I want to talk about what happened within the family after the hearing, because I think it's the part viewers are usually most curious about, and because it's the part that took the longest to actually settle into something livable. The first family gathering after the ruling was Thanksgiving, 5 months after the hearing, and I want to be honest that I very nearly didn't go. Nathaniel offered more than once to spend the holiday with just my side of the family instead, an offer I seriously considered before deciding that avoiding the Marsh family entirely would hand Constance a version of victory I wasn't willing to give her. The ability to make me disappear from family occasions the same way she'd once tried to make my marriage disappear from a legal document. So I went. I remember standing in the doorway of the same dining room where Constance had once toasted Whitney's boyfriend with a warmth she'd never extended to me, watching her greet me with a hug that was, if anything, even more clipped than usual, and thinking, with a strange kind of clarity, that I no longer needed that hug to mean anything in particular. I had spent 4 years trying to read warmth into Constance's gestures that had never actually contained any. I no longer needed to perform that reading for myself. I could simply notice the hug for exactly what it was: brief, correct, empty, and let that be fine, because my actual security in that room no longer depended on decoding Constance's feelings about me. It depended on a court order sitting in a file at Priscilla's office, which, I discovered that Thanksgiving, turned out to be a far more reliable source of peace than 4 years of hoping for approval had ever been. Whitney, Nathaniel's sister, called me directly the week after the ruling, something she'd never done in the entire 4 years I'd known the family, and told me, with what sounded like genuine, exhausted honesty, that she wasn't surprised at all by what our mother had done. Before that phone call, I want to mention, my relationship with Whitney had always been perfectly pleasant, but fundamentally surface level. The kind of sister-in-law relationship built entirely out of shared holidays and polite small talk, never anything deeper. In part, I now understand, because Whitney had spent years modeling her own guardedness on her mother's example, without either of us ever naming it directly. That phone call changed something structural between us, not just informationally, but in the actual texture of how we related to each other afterward. We started getting coffee occasionally, just the two of us, something that had never once happened in 4 years of my dating and then marrying her brother. I don't think that shift would have happened without the hearing forcing both of us to finally say true things out loud, instead of managing carefully around them. And I've come to think of that unexpected closeness with Whitney as one of the only genuinely good things that grew directly out of an otherwise painful ordeal. That Constance had made similarly quiet, controlling moves around Whitney's own now ex-husband years earlier during their marriage, moves Whitney had never fully understood the scope of until watching what happened to me made the pattern suddenly, retroactively legible. She did something to my prenup too, Whitney told me, her voice tight in a way that told me this admission was costing her something to make. I never pushed on it because Mark and I were already struggling for other reasons, and I didn't have it in me to fight two battles at once. I should have told you what she was capable of before your wedding. I'm sorry I didn't. I asked Whitney gently whether she wanted to tell me more, and what came out over the next hour was a version of Constance I'd suspected but never had confirmed with this much specificity: that during Whitney's marriage to Mark, Constance had quietly restructured a family-held property's title in a way that excluded Mark from any survivorship interest, similar in spirit, if not in exact mechanism, to what she'd later tried with Nathaniel and me, and that Whitney, at the time, had been too depleted by her marriage's other difficulties to fight it, choosing instead to let the property issue go in exchange for not adding a legal battle with her own mother to an already collapsing relationship. I used to think I was protecting my marriage by not making a thing of it, Whitney told me. Looking back, I think I was just protecting Mom from ever having to actually answer for what she does. I don't want to do that anymore. Watching you and Rosalind actually make her answer for it. I don't know, Sophie. It did something for me too, even though it wasn't my fight. I didn't need Whitney's apology to feel resolved, exactly, but I needed it to exist, the same way I think every person in these stories eventually needs someone in the family to simply say the true thing out loud, instead of managing around it indefinitely. What surprised me most was what came next. Whitney asked, almost tentatively, whether Rosalind might be willing to take a look at her own remaining trust interests. Just to understand what's actually there, not to start anything. I just want to know for myself instead of assuming Mom's version is the whole picture. I connected her with Rosalind the following week. I don't know all the details of what came out of that conversation because it was Whitney's to keep private, but I know that 6 months later, Whitney told me, over coffee, that she'd finally seen the full, accurate accounting of her own trust interests for the first time in her adult life, and that the experience had been, in her words, clarifying in a way I didn't know I needed. I think about that conversation often, how one daughter-in-law's fight for her own marriage's recognition ended up, almost as a side effect, giving her sister-in-law permission to finally ask questions about her own inheritance that she'd been too worn down to ask on her own behalf. Nathaniel's relationship with his mother has never fully recovered, and I want to be honest that I carry some complicated feelings about that, because I never wanted to be the reason a son and his mother became permanently estranged, even a mother who had done what Constance did. I remember a conversation Nathaniel and I had about 6 weeks after the hearing, late at night, where he told me he'd been having a recurring thought he hadn't wanted to say out loud yet, that he wondered whether his mother's inability to fully welcome me had less to do with me specifically, and more to do with a lifelong pattern of needing to feel like the architect of everyone's life inside her orbit. A pattern that had, he suspected, quietly shaped his own choices for years in ways he was only now starting to notice. I picked my college because it was the one she was proudest to tell people about, he told me. I don't think I ever really questioned that until watching her try to do something similar to us. Except this time, I could actually see it happening, instead of just living inside it the way I always had before. I didn't say much in response. I just held his hand and let him sit with that recognition at his own pace, the way I think everyone eventually has to sit with the uncomfortable realization that a parent's love and a parent's control were never actually the same thing, no matter how thoroughly childhood taught you to experience them as identical. But Nathaniel has been unwavering about one thing since the day Priscilla's call first came through, and it's the thing that, more than any court ruling, actually repaired what Constance's memo had tried to fracture. He told his mother, in a conversation I wasn't present for, but that he relayed to me afterward almost word for word, that he understood she might never fully embrace me the way he'd hoped, but that she needed to understand, permanently and without ambiguity, that any future attempt to use the trust, or anything else within her control, to undermine our marriage would be treated by him as a direct attack on his own family, not hers. His own, meaning the one he and I were building together, separate now, finally, from the one he'd grown up inside. Constance and I have found a kind of careful, distant civility since the ruling. Not warmth, I don't think warmth is coming, and I've made peace with that in a way I don't think I could have 4 years ago, back when I still believed her approval was something patience alone would eventually earn. We see her at holidays. She is polite. She has never once mentioned the memo, the hearing, or the attorney fees she was ordered to pay, and I've decided not to bring any of it up either. Not out of forgiveness exactly, but out of a recognition that some relationships settle into a permanent, workable coolness instead of resolving into anything warmer, and that a workable coolness, protected by an actual court order preventing her from trying this again, is a perfectly livable place to land. I want to describe one more moment before I move toward the end of this story, because it's small, and it happened almost a year after the wedding, but it stayed with me more than almost anything else from that entire period. Nathaniel and I had gone up to the family's Vermont property for a long weekend, the same property whose survivorship rights had been at the center of the original trust dispute. And Constance happened to be there too, having arrived a day earlier for what she described as routine maintenance oversight. We ended up alone together for about 20 minutes on the porch, while Nathaniel ran into town for groceries, the first time since the hearing that the two of us had been in a room without him or an attorney present to mediate the silence. Constance didn't apologize. I want to be clear about that, because I know some of you are hoping for a redemption moment, and I don't have one to give you. What she did instead was ask, almost carefully, whether I'd made any progress on a mill conversion project I'd mentioned in passing at Thanksgiving, a genuine, specific question about my actual work, the first one she'd ever asked me in 5 years that didn't come wrapped in the phrase little engineering projects. I answered honestly, at some length, about a 19th century textile mill I was helping convert into affordable housing, and she listened, actually listened, in a way that felt, for the first time, less like scrutiny and more like something adjacent to genuine curiosity. I don't know what that 20 minutes meant, if it meant anything at all beyond a woman deciding that ongoing hostility had simply become more exhausting than she had appetite for. I've stopped needing to know. I let it be a good 20 minutes, full stop, without requiring it to be evidence of anything larger. I think about Priscilla often. The way I imagine every person in these stories ends up thinking about whichever professional's ordinary diligence became the hinge their whole situation turned on. Doreen at the bank, Walt at the UPS store, and now Priscilla, a trust attorney who could have easily let a decade-long client relationship with Constance smooth over an uncomfortable phone call, and instead chose to follow the letter of a clause her own late client had insisted on including specifically to protect people exactly like me. I met with Priscilla once more, months after everything had resolved, ostensibly to finalize some remaining paperwork around the verification protocol the court had ordered, though I suspect we both understood the meeting was really about something else, a kind of closure neither of us had gotten to have during the actual dispute, when everything moved through letters and hearings instead of conversation. She told me something that day that I've carried with me since, something about her own career that reframed the entire experience for me one more time. She said that in 22 years of trust and estate law, she had drafted hundreds of spousal protection clauses very similar to the one Nathaniel Sr. had insisted on, and that in her experience, the overwhelming majority of them existed as pure formality, boilerplate language nobody ever expected to actually need, included because a good attorney includes protective language as a matter of course, the legal equivalent of a smoke detector nobody expects to hear go off. Most of my clients never think about that clause again after we sign the trust, she told me. Walter was different. He asked me, specifically, more than once, whether the notification requirement was airtight, whether there was any way it could be quietly circumvented by a co-trustee who wanted to avoid it. I remember thinking, at the time, that he was being unusually thorough for a man who by every account had a functional, loving marriage. It wasn't until your situation that I understood he wasn't being thorough about marriages in the abstract. He was being thorough about his own wife, specifically because he already knew, on some level, exactly what she was capable of doing quietly if nobody built a tripwire in her path. I asked Priscilla, somewhat hesitantly, whether she thought Nathaniel Sr. had ever confronted Constance directly about whatever behavior had prompted that level of specific caution. Priscilla shook her head. I don't know. I never asked, and it wasn't my place to. But I think, Sophie, some people spend their whole marriages quietly managing a partner's tendencies instead of naming them outright, hoping structural protections will do the naming for them so they never have to have the harder conversation themselves. I think Walter built you a shield instead of ever telling his wife directly what he was building it against. I've thought about that theory more times than I can count since. I don't know if it's true, but it would explain a great deal about a woman who, even now, seems to genuinely believe that quietly managing outcomes is simply how careful people operate, rather than understanding it as the specific harm it actually causes to the people being managed. I've thought a great deal, in the year since all of this resolved, about what it actually means to marry into a family with that much institutional history and that much institutional money, because I don't think I fully understood, going into it, that a wedding day and a legal marriage are, in families like the Marshes, two entirely separate events that don't automatically confer the same status on each other the way I'd naively assumed they would. I want to share one more reflection before I close this out, something that came from an unexpected place, a conversation with a colleague at my own firm, an older structural engineer named Robert, who'd been doing adaptive reuse work for almost 3 decades, and had, over a work lunch about 8 months after the hearing, asked me, gently, why I seemed different lately, more settled somehow, in a way he couldn't quite name. I ended up telling him a condensed version of the whole ordeal, mostly because I was tired of carrying it alone in professional spaces where nobody knew, and Robert, who has spent his entire career assessing whether century-old structures can safely bear new weight, said something that stopped me completely. You know what we do, Sophie, when we're assessing an old mill building for conversion. We don't trust what the original architect's drawings say the load capacity was. We test it ourselves, directly, because paper specifications and actual structural reality drift apart over decades, sometimes because of honest wear, sometimes because someone made a quiet modification nobody documented properly. It sounds like what happened to you is exactly that, except the building was a family, and the modification nobody documented properly was your mother-in-law's actual feelings about you, dressed up the whole time in paperwork that said something else. I've held on to that comparison since, because I think it names something true about every story on this channel, not just my own. That the gap between what a family's paperwork says and what a family's paperwork actually reflects is often exactly where the real danger lives, quietly, until someone finally tests the load themselves instead of trusting the original drawings. What I want to leave you with, more than the specific mechanics of trust law or fiduciary duty, is the thing I learned about my own instincts through this entire process, because I think it's the part that translates most directly to anyone watching who doesn't have a trust fund or a family real estate empire anywhere in their own life. I had spent 4 years quietly absorbing Constance's low-grade dismissiveness, telling myself it was ordinary friction that would eventually soften, because the alternative, actually naming what I was sensing, out loud, to Nathaniel, to myself, felt disproportionate to the evidence I had at the time. A compliment here, a hug there, nothing you could point to as proof of anything. It took an actual document, an actual erasure with her own signature on it, before I let myself fully believe what some earlier, quieter version of me had already suspected for years. I don't think that delay was foolish. I think it's simply how most people are built. We extend the benefit of the doubt until the doubt becomes undeniable, and there's a kind of grace in that patience even when it turns out, eventually, to have been misplaced. But I also don't think I'll ever again wait for a signed document before trusting what I already sense about how someone treats me when they think no one who matters is watching closely enough to notice. Nathaniel and I are expecting our first child now, a detail I share not because it resolves anything about Constance specifically, but because it's forced me to think, more concretely than ever, about what kind of family structure I actually want to hand down to someone who won't have any choice at all about which family they're born into. I found out I was pregnant about 4 months after the hearing, and I remember the strange, layered feeling of telling Nathaniel, joy, unmistakably, but also a quieter, more complicated undercurrent, wondering what it would mean to raise a child who would grow up spending holidays in that same Georgian colonial, under that same portrait of Nathaniel Sr. in the front hall, with a grandmother whose capacity for quiet, procedural control I now understood far more intimately than I'd ever wanted to. Nathaniel felt it too. We spent an entire weekend, early in the pregnancy, having the kind of conversation neither of us had ever needed to have before all of this happened. Not about names or nurseries, but about what boundaries we wanted to set, explicitly and early, around Constance's involvement in our child's life, long before there was even a child to protect. We agreed, together, that our child would know Constance, would have a grandmother, because I never wanted a child of mine to inherit my own estrangement as though it were automatically theirs to carry. But we also agreed that we would never again let ambiguity do the work that explicit boundaries should be doing instead. No unstated assumptions about custody arrangements during visits, no quiet trust modifications made without both of us present and fully informed. Nothing left, ever again, to the version of trust that had once let a memo like Constance's happen in the first place. I've already spoken to Rosalind about updating our own estate documents, long before we technically need to, specifying clearly, in language that leaves no room for quiet reinterpretation later, exactly how we want our own child's future protected, regardless of who ends up serving in whatever fiduciary roles our own family eventually requires. I think about Nathaniel Sr. often now, a man I never met, who apparently understood something about protection that took me an entire legal battle to learn secondhand. That love, inside families with real institutional power, sometimes isn't enough on its own. Sometimes it has to be written down, specifically, deliberately, with a lawyer's precision, by someone who loved their family enough to imagine, in advance, exactly how that love might someday be quietly undermined by the very people meant to protect it. That's my story. My mother-in-law had my husband declared unmarried on his family's trust 2 weeks after our wedding, and I found out because a trust attorney, following a clause her own late husband had insisted on writing specifically to protect people like me, called me directly instead of letting the family quietly handle it among themselves. If you've ever had someone in your life try to use paperwork, procedure, or plain unilateral authority to make your reality smaller than it actually is, I want you to hear this clearly. The truth doesn't need anyone's permission to still be true, and it doesn't stop being true just because someone with more institutional power than you decides, quietly, to write it down differently. If this story resonated with you, subscribe to True Family Drama. Tell me in the comments whether you've ever had to fight to be recognized as exactly what you already were, and I'll see you in the next one.